So you've had your trial. Now what? In this video, I'm going to talk to you about what an entry hearing is. Hi, I'm Sean Palmer with the Palmer Law Firm, and I've been practicing family law in the great state of Texas for the last 19 years, primarily in the Houston and Galveston area, and exclusively in the area of family law. And we're going to talk today about what happens after your court hearing and what is going to happen with the next step. So to explain what happens after the case is over, when each party has put on their evidence, then it's up to the judge, or in some cases a jury, to make a ruling on the case, or what we call a judgment. So there are three things to keep in mind at the end of the case about getting the announcement from the court about what is going to happen, like what has been ordered. So there is a thing called a rendition, there's a thing called a signing, and there's a thing called an entry. And those things have different meanings at different points of time. So let's begin with rendering. So a rendering resolves the issues in the case. It's usually given orally by the judge as a pronouncement in open court about who won the case and what duties are going to be put upon one person, or what rights are going to be given. Basically, the outcome of the case. The judge will make a usual oral rendition if it's a bench trial. Bench trial is when you're in front of the judge. If it's a jury trial, there's a different situation for that. We'll save that for another video. But a rendition is the time, usually at the end of the trial, when the judge makes an announcement, and that is now the order of the court. Now, that announcement will be made on the record, presuming that a record has been kept throughout the proceedings, which is almost always the better way to do it. So once the oral judgment is done, you'll look over and you'll probably see your attorney furiously writing and making sure that everything the judge is saying is down on paper. This is because the judge is going to order one of the two attorneys to draft up what he's saying into a formal written order. And that formal written order is the thing the judge will actually sign. So one of the questions is often asked is, well, when does this take effect? When does what has just happened take effect? When do I have to perform these duties, or when does the other party have to perform those duties? It's at the time the judge makes the announcement. That's when the parties are bound under the order of the court. So you got to start doing what the judge said at that moment from that day forward. However, we still need to put all of the order into a formal written order that will be signed by the judge. And again, one of the two attorneys are going to be ordered to draft that. Okay. So what happens next is then the attorneys will go back to the office and they will begin to draft what the judge had said based on the notes that they had. On rare occasions, your attorney may ask the court reporter to print out what they had been typing if they need to know the word for word thing that the judge said, but we try to avoid that by taking careful notes at the time so we don't have to order that the minutes from the court. So the attorney will then do their best job to type all that out in the proper format. And you know, in a lot of the cases we have some recognized language, and we have some practice manuals that we use as guides in the wording. We don't try to reword everything on every single case, because everybody knows this is the proper way to word a particular order. Let's say somebody has been ordered to pay child support. So a child support order should contain basically the same language on every single order about how to pay those child support obligations. So the attorney is then to draft that up in a timely way, and then to send it to the other attorneys for their approval. The attorneys must agree on the wording of the order that will be presented to the judge for signature. And normally we can work those things out. The attorneys will go back and forth a little bit about what they heard the judge say, or how things should be worded. but basically it's hoped that the attorneys will always be able to sort that out between themselves by sending drafts back and forth. It does happen on occasion, however, that the parties cannot agree on the wording of the order, and there's going to be a dispute about one version versus another version of what the judge said. In that instance, an entry hearing may be scheduled to bring the matter before the judge once more. Now, this isn't a hearing to talk about what was already ordered. It's just a hearing to let the judge decide, if the attorneys can't, how the actual written order should be worded. An entry hearing will usually happen maybe 2 weeks, maybe a little bit longer, depending on the calendars and things like that, to give the attorneys enough time to draft and to send them back and forth. But once the judge decides on the version of the order that he or she wants, then the judge will sign that preferred order. Now, signing is an important milestone, because although it doesn't set the time frame for when you should start following the orders, you need to start following the orders back when the judge orally proclaimed them, like from that day forward. But the signing of the order is the trigger point for a lot of the timetables that you're going to need if an appeal is going to have to happen. So the signing of the order is the date that's referred to for things like, when can you file an appeal in the next court, or for things like when can the judge amend their judgment. There's timetables that start. It all happens from the date the judge signs the order. So the signature date is important, but it's not the date when you should that's when I have to start following the order, usually. The other thing to know about the entry is that a judgment is signed, and then it is entered into the court's record. The entering into the court record of the signed order is called entry, and it's just a ministerial act, of what we call just a clerk's function to do that. So the actual entering of the signed order into the record of the court really doesn't have much significance, but that's the name of the hearing that we call it an entry hearing. So it's a little bit of a misnomer. It's kind of confusing, but it's really, if you have an entry hearing, it's a hearing for the attorneys to argue about how the order should be drafted. Some courts allow oral hearings for that. Other courts just say, give us your versions and we'll decide. So a hearing may or may not be necessary. But in general, your presence is not needed as a client at an entry hearing, because all we're talking about is how the thing is worded, not entering any new evidence, or we don't need testimony or anything like that. We're not relitigating the case. We're just getting the paperwork sorted out. So if there is an entry hearing scheduled for you, typically you're not going to need to take time off from work and go and be present. Your attorney will let you know the outcome of it, and the version of the order that the judge signed. So it's kind of a process, but you need to have a signed order. You don't want to just have a rendition from the judge, an oral rendition, and then not have a signed order after that. The reason is because you can't hold the other party accountable to what the order is unless it's in a written format that can then be used in potentially a future enforcement hearing. To have an enforcement hearing, you have to have a signed, written and signed order to be able to give the other party notice and various other things. But it's absolutely critical that you do, at the end of it all, whether it takes a little or a lot of time, but you still need to have a signed order by the judge, so that you have you're sure that the order is going to be followed by the parties, and that you have the power to enforce or appeal if that's what you need to do. Well, I hope this has been helpful to you, and if you have any questions, please give me a comment below, and I wish you the best of luck.